Ladies and gentlemen, South Africa didn't just witness a court ruling today. It witnessed a full-blown political thriller dressed up as legal proceeding. The kind where the main character doesn't just walk into court hoping for justice, but arrives with contingency plans so detailed you would think this was a military operation rather than a sentencing hearing. And at the center of it all, of course, was Julius Malema, a man who has built his entire political identity on pushing limits, testing boundaries, and daring the system to respond. And this time, the system finally did. Because the moment that sentence dropped, everything changed. 5 years. Not suspended, not softened, not negotiated, nothing removed for good behavior. 5 full years.
Maybe I should be clear. Okay. Sorry for that. All right. After careful consideration, and I can assure you I have done so, free of any interference, this judgment or sentence is the sentence of this court and this court alone. In respect of count 1, you are sentenced to a period of 5 years imprisonment. In respect of count 2, you are sentenced to a period of 2 years imprisonment. In respect of count 3, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 4, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 5, you are sentenced to pay a fine of 20,000 rand or to undergo 6 months imprisonment. In terms of Section 280, subsection 2 of Act 51 of 1977, the court orders that the sentence imposed in respect of counts 2, 3, 4, and 5 run concurrent with the sentence imposed in respect of count 1. You may be seated, thank you.
The kind of sentence that doesn't just punish, but sends a message. The kind of message that says we are no longer entertaining this. And for a brief moment, it looked like the man who thrives on pressure had finally met a system willing to apply even more pressure back. As a seasoning, the judge added 2 years for another count and sprinkled some fines for the rest of the counts, with imprisonment options for 6 months for each fine. Now, here's the thing. The conviction itself didn't shock many people because legally it appears clean, straightforward, and difficult to poke holes in using the reasonable person standard, which is why even critics aren't really focusing on that part. But the real controversy, the real debate, the real firestorm is the sentence. Because in law, sentencing is never supposed to be one-dimensional. It is supposed to be a balancing act, a careful weighing of aggravating and mitigating factors, a process where the court looks not just at what was done, but who did it, when it happened, what has happened since, and whether there are reasons to reduce the punishment. But in this case, it's as if mitigation walked into the courtroom and was politely told to wait outside. No real weight given to the time that has passed, no emphasis on the absence of similar conduct over the years, no consideration strong enough to reduce the sentence based on family life, leadership role, or personal development. Instead, the court went straight to maximum punishment. Well, not maximum, but really, it looks like maximum. And that is where legal eyebrows started rising across the country, because that kind of zero weighting on mitigation is rare. And when something rare happens in law, people start asking questions. Of course, the counter-argument is just as powerful. because the prosecution likely leaned heavily on the aggravating factors, and in Malema's case, those are not small things. They include his massive public influence, his history of provocative rhetoric, the perception of recklessness, and the idea that someone in his position should know exactly how far is too far. So, instead of his status helping him, it may have worked against him, turning what could have been mitigation into aggravation, effectively saying, because you are who you are, we expect more from you, not less. So much for everyone is equal before the law. And just like that, the court delivered the harshest possible message. But here's where the story shifts from serious legal debate into something that feels almost cinematic, because the moment the sentence was handed down, Malema's legal team, led by formidable Tembeka Nkaitobi, didn't hesitate for even a second, immediately applying for leave to appeal both the conviction and the sentence, a move that is standard in procedure, yes, but the speed, coordination and readiness behind it told a completely different story.
And finally, in relation to the conviction, Your Worship, what we say is at the very least, it cannot be said that now the court might find differently or have a different assessment of all the evidence led in this trial. Consequently, it is respectfully submitted that the accused is not only a reasonable, but a good prospect of success on appeal, and this application for leave to appeal against the convictions ought to be granted. In relation to sentence, Your Worship, we submit the following. We say that the sentence imposed by this Honourable Court is startlingly inappropriate to the extent that it induces a sense of shock. We say further, due regard being had to the prevailing circumstance at the time of the commission of the offences, and more specifically that they all relate to the same event in a very limited period of time that did not exceed 1 minute, all of the counts ought to have been taken as one for the purpose of sentence. There is no need or basis to impose separate sentences in respect of each charge, as this court did. We say further, insufficient regard was had to the personal circumstances of the accused. Most significantly, he is a 45-year-old first offender who was 37 years old when these offences were committed. He has not been convicted of any other offences in the interim. Additionally, he is married, he has 3 children and a wife to support. He is in full-time employment. He is also involved in community projects and regarded as an asset to the community. There is no basis to contend that he is a danger to society, thus ought to be removed from society. In this regard, Your Worship, I wish to highlight that no regard was had to the fact that he's led a blameless life during the duration of this trial, and he hasn't committed any other offence, and this was not taken into account in the sentence that was imposed.
This was not reaction, this was preparation. And then came the magistrate's decision, a split ruling that changed everything in an instant. Leave to appeal the conviction was denied, meaning the guilty verdict stands for now, firm and intact. But leave to appeal the sentence was granted, meaning the court itself acknowledged that another court could reasonably come to a different conclusion regarding the 5-year term.
Abides by its decision as stated on record. This court has not had a change of heart and clearly stands firm on its decision to convict. Therefore, leave to appeal in respect of conviction is not granted. I have not finished, please. However, with regards to sentence, after listening carefully to the address placed on record, in respect of sentence, there is always a possibility that another court may come to a different conclusion regarding sentence. Therefore, this court does not have any intention to stand in the way of such a possibility. Safe to say, no, I'm not going to add that. The court will not stand in the way, and therefore leave to appeal sentence in this matter is granted.
If the court please assume.
Thank you.
That single decision flipped the entire situation. Because once leave to appeal the sentence is granted, the law automatically suspends the sentence, and just like that, the reality of immediate imprisonment vanished, and Malema walked out of court and went home the very same day, transitioning from 5 years behind bars to free pending appeal in a matter of hours. Now, if that was the whole story, it would already be dramatic. But what makes this case truly extraordinary is what was happening behind the scenes. Because this was not a situation where the defense team showed up hoping things would go their way. This was a situation where every possible outcome had already been mapped out in advance, including the worst case scenario. Because if the magistrate had denied leave to appeal entirely or refused bail pending appeal, a contingency plan was already in place. And not just any plan, but one that included a helicopter on standby, ready to fly the legal representatives immediately to the Makanda High Court to file an urgent petition. Yes, an actual helicopter waiting to go to Grahamstown, timed, prepared, and waiting as part of a strategy to ensure that no matter what happened in that courtroom, Malema would not spend a single night behind bars without a fight at the highest level. At the same time, multiple legal teams were already deployed across different locations. One team at the Magistrates Court in East London, ready to file applications instantly. Another team already stationed at the High Court in Makanda, prepared to act the moment they received the signal, and additional support structures positioned to escalate the matter without delay. Meaning that if things had gone badly, the legal battle would have shifted to the High Court within hours, not days, not weeks, but the very same afternoon. This is not normal legal preparation. This is strategic anticipation at the highest level. The kind that turns a courtroom into a command center and a legal team into a coordinated response unit. That's why they call him the Commander-in-Chief. And perhaps the most fascinating part of all this is that Malema himself had already publicly outlined this plan days before the sentencing, openly stating that his team was ready to escalate the matter all the way up the judicial ladder, including the Constitutional Court of South Africa if necessary, making it clear that this was never going to end in one courtroom, regardless of the outcome. So, when the magistrate granted leave to appeal the sentence, all of that dramatic contingency, the helicopter, the urgent petitions, the rapid escalation strategy suddenly became unnecessary. Not because it wasn't ready, but because it didn't need to be activated. And yet, its very existence tells you everything you need to know about how high the stakes were and how seriously this moment was being treated. Now, the case moves to the Makanda High Court, where the sentence will be re-examined, and based on how these things usually unfold, the most likely outcome is that the conviction remains intact while the sentence is reduced, bringing it back into alignment with established sentencing principles and the balancing of mitigating factors that many feel was missing the first time around. But beyond the legal outcome, there is a political dimension that cannot be ignored, because moments like this don't just end in court. They echo in the public sphere, shaping narratives, fueling support, and creating opportunities. And for Malema, this may become less of a setback and more of a platform, a chance to reinforce the idea that he is a target of the system, a narrative that has historically worked in his favor. And with the 2026 elections at the door, this is a boost for the EFF. In the end, what South Africa witnessed was not just a sentencing, but a collision between law and politics, between consequences and strategy, between a system trying to assert control and a political figure who came fully prepared to resist it, at every level. And while the first round may have produced a dramatic headline, the real battle is only just beginning, because in this case, the courtroom was never the final destination. It was just the opening scene. Ladies and gentlemen, if you want more breakdowns like this, raw, unfiltered, and cutting straight through the noise, make sure you subscribe to Mzansi Roast News. Hit that like button and drop your take in the comments, because in South African politics, the drama never ends. And trust me, we are just getting started.